Welcome to The Docket. I'm your host, Corey Snow. This is episode 14. In late August 2023, multiple defendants in the Georgia RICO case against Donald Trump and 18 co-defendants filed for a speedy trial under Georgia law, meaning the state must set a trial date and conduct the trial within a specified time frame. On August 30th, 2023, DA Fani Willis filed a motion urging the court to proactively inform the defendants of the specific consequences to their case and asked that they go personally on the record, saying they understand and still wish to seek a speedy trial. What follows is an audio narration of that motion. Please note that to improve listenability, most citations are omitted. Those that are not have been simplified to stating only the name and year of the case. The original document, including all citations and footnotes, is available at a link provided in the show notes. If you are so inclined, please consider supporting my Patreon at patreon.com/docketpod, which allows me more ability to pay pacer and other court fees to obtain documents for me to narrate for you to listen to. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the Superior Court of Fulton County, State of Georgia. State of Georgia v. Donald John Trump, Rudolph William Louis Giuliani, John Charles Eastman, Mark Randall Meadows, Kenneth John Chesebro, Jeffrey Bossert Clark, Jenna Lynn Ellis, Ray Stallings Smith III, Robert David Cheeley, Michael A. Roman, David James Schaefer, Sean Micah Tresher Still, Stephen Cliffgard Lee, Harrison William Prescott Floyd, Trevian C. Cootie, Sidney Catherine Powell, Kathleen Alston Latham, Scott Graham Hall, Misty Hampton, a.k.a. Emily Misty Hayes, defendants. Case number 23SC188947. Motion for court to advise defendants of effects of speedy trial demand upon evidentiary and procedural rights and brief in support. Comes now the State of Georgia by and through Fulton County District Attorney Fani T. Willis, and requests that this honorable court advise the defendants of the effects of their speedy trial demands upon evidentiary and procedural rights, and provides the following in support. 1. Introduction. On August 14, 2023, a Fulton County grand jury returned an indictment charging the 19 defendants above with 41 various charges, including violation of the Georgia RICO Act, solicitation of violation of oath by public officer, false statements and writings, forgery, influencing witnesses, computer crimes, conspiracy to defraud the state, and other offenses. The statutory speedy trial demands filed thus far in the case, and any which may be filed henceforth, will affect various issues related to discovery and procedure. Accordingly, the state presents the following argument and citation of authority in order to assist the court in resolving any dispute which may arise with regard to those matters. 2. The procedural posture of the case has been dictated by defendants' speedy trial demands. As will be delineated infra, under Georgia law, the defendant's decision to file a speedy trial demand limits certain of their options in this case. Namely, 1. The defendants cannot now argue that they are entitled to the state's discovery responses 10 days in advance of trial. Smith v. State, 2002, Ruff v. State, 2004. 2. The defendants cannot now argue that they are entitled to notice of the state's similar transaction evidence 10 days in advance of trial. Brown v. State, 2005. 3. The defendants are now precluded from calling any witnesses whose statements were not provided to the state at least 10 days in advance of trial. Clark v. State, 2005. And 4. The defendants cannot now complain that they received less than 7 days' notice of the trial date in this case. Linkus v. State, 2002. 3. Procedural history of this case. On August 23, 2023, the defendant, Kenneth John Chesebro, opted into the discovery provisions of OCGA 17-16-1 et sequentia, the discovery statute, and on August 24, 2023, filed a demand for speedy trial pursuant to OCGA 17-7-170A. On August 25, 2023, defendant Sidney Catherine Powell filed a demand for speedy trial pursuant to OCGA 17-7170A. On August 24, 2023, pursuant to the defendant's demand for speedy trials, the court set October 23, 2023 as the trial date for this case. Notice of the trial date was distributed by this court on August 24, 2023. Notwithstanding the constraints foisted upon it by the defendant's speedy trial demands, the state, in the spirit of good faith, has begun the process of supplying the defense with responses to its discovery requests. Those efforts have included contacting each attorney of record for the separate defendants who have filed an entry of appearance pursuant to Uniform Superior Court Rule 4.2, and requesting that these attorneys provide an electronic storage device of a capacity of at least 2 terabytes for copying of the initial batch of discovery. Counsel for the state has further requested that each defendant, through his or her attorney, provide this electronic storage device to the Fulton County District Attorney's Office by the close of business on Tuesday, September 5, 2023, and has informed these attorneys that the initial batch of discovery will be served on or about September 15, 2023. 4. The defense has waived 10 days' notice of discovery. By filing their speedy trial demands in this case, the defendants have personally, willfully, and deliberately narrowed numerous options that would otherwise be available to them under Georgia law. In connection with any rights under OCGA 17-16-1 et sequentia, the defendants have effectively waived any claim to access the state's file information 10 days in advance of trial. Smith v. State, vacated, overruled on other grounds at Patterson v. State, 2006. Hughes v. State, 2010. The remedies for the state's failure to comply with the reciprocal discovery requirements include a continuance and, quote, upon a showing of prejudice and bad faith, end quote, exclusion of the evidence not disclosed. OCGA 17-16-6. Excluding evidence is a particularly harsh sanction that should be imposed only where there is a showing of both prejudice to the defense and bad faith by the state. Higuera-Hernandez v. State, 2011. Criminal defendants are obligated to request a continuance to cure any possible prejudice from the state's failure to comply with the discovery statute. Major v. State, 2010. Certiorari denied, 2011. In cases like this, where the defendants have elected to file a statutory speedy trial demand, Georgia appellate courts approve of trial judges providing defendants with 2 options. 1. Go to trial without a review of discovery, or 2. Waive the speedy trial demand and seek a continuance. Ruff v. State, 2004, certiorari denied. Significantly, in Ruff, the court stated unequivocally that the defense is, quote, obligated to request a continuance to cure any prejudice, end quote. Ibid. In a case involving a defendant's statutory demand for speedy trial, the Georgia Supreme Court unanimously affirmed a defendant's conviction where the trial court 1. Denied the defendant's continuance request, and 2. Denied the defendant's motion to exclude all state's evidence not supplied 10 days prior to trial. Quote, under all of the circumstances, we find that the trial court did not abuse its broad discretion under OCGA 17-16-6 by denying a continuance and refusing the harsh remedy of evidence exclusion for the untimeliness of discovery. Instead, the court used its judgment to fashion a remedy appropriate to a case in which there was a speedy trial demand, and no other reasonable time to proceed with the rather lengthy trial within the constraints of that demand. End quote. Higuera-Hernandez v. State, 2011, emphasis added. In this case, if the defendants do not seek a continuance or waive their speedy trial demand, they cannot claim any error in proceeding to trial without the state's discovery responses. Consequently, the defense has barred itself from objecting to the introduction of witness testimony and evidence on the grounds of lack of due notice. The state respectfully requests that this court rule in accord with the foregoing case law and that it require that the defendants personally place upon the record that this is their decision and preference to proceed in this fashion prior to the trial of this case. 5. The defense has waived 10 days' notice on similar transaction evidence. Significantly, a similar waiver is evident under Georgia law when it comes to notice provisions of USCR 31.1 pertaining to similar transaction evidence, where, as here, a criminal defendant files a speedy trial demand, Georgia law states that he can no longer claim that he is owed, quote, 10 days' notice, end quote, in advance of trial of the state's similar transaction evidence. Brown v. State, 2005, certiorari denied. Again, the defendants in this case have not sought a continuance or waived their speedy trial demand. As such, they cannot claim any error in proceeding to trial without 10 days' notice of the state's similar transaction evidence. Accordingly, the defense has waived its objections to the introduction of similar transaction evidence on the basis of insufficient notice. The state respectfully requests that this court rule in accord with the foregoing case law and that it require that the defendants personally place upon the record that this is their decision and preference to proceed in this fashion prior to the trial of this case. 6. The restrictions on the defendant's presentation of evidence other than their own testimony. As the case at bar was set for trial pursuant to the defendant's speedy trial demands, our appellate courts approve of precluding the defense from calling any witness whose statements were not provided to the state at least 10 days in advance of trial. Clark v. State, 2005, certiorari denied. See also OCGA 1716-7, 10-day rule for witness statements, OCGA 1716-8, 5-day rule for witness information, OCGA 1716-8, 5-day rule for physical evidence. In Clark, the conviction against a defendant who proceeded to trial without calling his witnesses was upheld. Significantly, the Court of Appeals approved of the trial court requiring the defendant to choose between 1. Waiving its speedy trial demand and seeking a continuance, or 2. Proceeding to trial without defense witnesses not provided to the state. In this case, the rule of Clark should be applied to preclude the defense from calling any witnesses whose statements were not served upon the state 10 or more days in advance of trial. Similarly, the defense should be prohibited from admitting any evidence that was not served upon the state 5 days or more in advance of trial. The importance of a defendant seeking a continuance and waiving a speedy trial demand in order to obtain information potentially vital to the defense was underscored in Dingler v. State, 2006. In Dingler, the defendant specifically sought a continuance in order to obtain a court-appointed expert to review the state's DNA evidence. The Dingler defendant's commensurate motions characterized the state's DNA test results as, quote, the state's only evidence against Dingler, end quote. Dingler at 722, emphasis added. Importantly, the trial court in Dingler did not provide the same two options: go to trial without the evidence in question, or waive the speedy trial demand and seek a continuance, approved of in Ruff and Clark. Instead, the judge in Dingler denied, out of hand, the continuance request and refused to entertain the timely motion for funds to allow independent reviews of the state's DNA testing. Under Dingler's specific circumstances, the conviction was reversed. Dingler at 723, quote, further, the record shows that Dingler timely sought an expert to assist him in challenging the admissibility of the state's DNA identification as evidence. Without such an expert, Dingler was left with no witness on his behalf, end quote. Emphasis added. Once again, in the instant case, the defense has not, to date, sought a continuance of any kind. As such, by its own election, the defense has determined that it is in its own best interest to proceed to trial without full benefit of the state's discovery responses or the presentation of evidence that might support its contentions. Furthermore, Dingler is inapposite. There is no defense request for a continuance in order to procure funding for expert testimony analysis pertaining to a sole defense a la Dingler, present or indicated here. Accordingly, the state respectfully requests that this court rule in accord with the foregoing case law and require that the defendants personally place upon the record that this is their decision and preference to proceed in this fashion prior to the trial of this case. 7. The defendants cannot complain about less than 7 days' notice of a trial date. While it is true that USCR 32.1 generally requires that notice of trial, quote, not less than 7 days before the trial date or dates, end quote, the Georgia Supreme Court has held that, quote, compliance with Rule 32.1 must be judged in the circumstances of each case, end quote. Higuera-Hernandez v. State, 2011. In Higuera-Hernandez, a unanimous Georgia Supreme Court affirmed the convictions of a defendant who filed a statutory speedy trial demand and who, as a consequence, did not receive 7 days' notice of the trial date. Quote, furthermore, it was apparent that, by his demand for trial, appellant had shortened the time for trial, which constituted a factor for the trial court to consider when setting the trial date. The trial court's statements during its colloquy with counsel were tantamount to a ruling that its calendar did not reasonably allow for appellant's case to be continued within the time permitted by OCGA 177170, and that therefore his demand for speedy trial could not be met if a continuance was granted. In other words, the trial court was attempting to comply with the demand for trial, and the only way to do so was by deviating from the notice requirement of USCR 32.1. End quote. Higuera-Hernandez v. State, 2011. Emphasis added. The defendant's decision to proceed with a demand for speedy trial in this case also precludes them from arguing that they received less notice of the trial date, as is generally required by USCR 32.1. Where, as in this case, a trial court is attempting to comply with a speedy trial demand, deviations from USCR 32.1 are authorized. Linkus v. State, 2002, affirmed sub nomine on other grounds at Jones v. State, 2003. Under the circumstances of this case, the defendants who have filed a speedy trial demand, and any who may file a speedy trial demand, cannot complain that they did not receive sufficient notice of the trial date, should it be in less than 7 days in advance of trial. Their filing of a statutory speedy trial demand precludes such an argument. The state respectfully requests that this court rule in accord with the foregoing case law and that it require that the defendants personally place upon the record that this is their decision and preference to proceed in this fashion prior to the trial of this case. 8. The defendants should be addressed directly in order to rule out the potential for induced error. In Hubert v. State, 2009, certiorari denied, the defendant filed a statutory demand for speedy trial and received the state's discovery responses only 7 days prior to trial. Noting that the defense in that case had announced, quote, we're ready, end quote, for trial, the Georgia Court of Appeals rejected the notion that the defendant in Hubert was forced to make a Hobson's choice, requiring him to decide whether he desired to proceed to trial on the day his case was called. Quote, defendant contends that the trial court effectively prevented him from withdrawing his demand for speedy trial and requesting a continuance. Defendant's assertion is not supported by the record and completely lacks merit. End quote. Hubert at 440. The defendants in this case should be asked directly and on the record as to whether, knowing of the consequences to their defense, it is their decision and preference to go forward to trial at this time. Should they refuse to waive their speedy trial demand and request a continuance, then any harm to the defendants would be invited by the defense and therefore not reversible error. Hubert v. State, quote, self-induced error is not grounds for reversal, end quote. 9. Conclusion. In connection with statutory speedy trial demands, the Georgia Court of Appeals explicitly enunciated that the pleadings cannot be used collusively. Quote, contrary to the view of some, our legal system is not simply an elaborate game of gotcha. This court does not endorse acquittal by ambush on the part of a defendant any more than it does trial by ambush on the part of the state. Nor do we condone induced error. The object of all legal investigation is the truth, and procedural rules are in place to further such goal in an orderly fashion. Price v. State, 2000, certiorari denied. Jones v. State, 2003, certiorari denied. The state is entitled to a fair trial, as well as the defense. A defendant who does not possess discovery materials cannot file a statutory speedy trial demand and then claim that the state's evidence should be excluded on the basis of this court adhering to that same demand and scheduling accordingly. In other words, this court should not be transformed into a forum for, quote, gotcha. By filing a statutory speedy trial demand, the defendants elected to proceed to trial without the benefit of the type of prior notice of the state's discovery and similar transaction evidence that would have otherwise been afforded to them. Similarly, that decision also cost the defendants the use to any evidence not timely served upon the state. It also prevents the defendants from arguing that they received insufficient notice of the trial date in this case. Should the defendants in this case desire to proceed to trial under these circumstances, then they should be required to confirm it personally and on the record prior to trial. Wherefore, the state respectfully requests that this honorable court advise the defendants of the effects of their speedy trial demands upon evidentiary and procedural rights, enter ruling and proceed in this case consistent with the arguments, requests, and Georgia law as stated herein, and for such other and further relief as this court deems just and proper. Respectfully submitted this 30th day of August, 2023. Fani T. Willis, District Attorney, Atlanta Judicial Circuit. Signed, F. McDonald Wakeford, Georgia Bar Number 414898, Chief Senior Assistant District Attorney. Signed, John W. Will Wooten, Georgia Bar Number 410684, Deputy District Attorney, Fulton County District Attorney's Office. This concludes this episode of The Docket. I hope you enjoyed this narration. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.